We have called this emergency meeting of the Law Nerds to order because there is a new filing in the Tati Westbrook without a crystal ball defamation lawsuit, and we're doing a live reacts. I haven't read it yet. I literally just got back home, came and sat down. We got the nails on. Came and sat down, pulled this document up on Pacer, and I'm here to read it with y'all and do a live react. It is time, Law Nerds, to get into this. So today, we're going to break down this latest Saltz filing. It is a response. We are going to do a quick road so far, my thoughts on this lawsuit, where we're at, and then your questions. We've got a lot to get through. I'm really curious as to what's in this. I bet you are too. Are you curious? Are you curious? Let me know in the comments if you're a replay crew. Let me know in the chat if you're here live. If you're curious about what's in this document, I want to hear it. I want to hear it. Let's go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I even put on my Facts Not Fuckery shirt today. We've got the shirt. We've got the official shirt because, I don't know, we just went with red lights. We went with DEFCON WT fuckery. What the fuckery? Because, look, the last motion that Saltz responded to pointed out that Brown had misrepresented things to the court, perhaps put things in the Lorianne declaration that weren't specifically accurate. And now we are here. The response today is to Brown's, hey, can I still be your lawyer motion? The motion to qualify counsel. The things I have said about this motion are, why the fuck was this filed? Is this even timely? Like, can we even hear this motion? How do we even know? And Brown attached all these emails back and forth between him and Jazzy Jeff saying, hey, this is an issue. And Jazzy Jeff's like, bruh, we don't even know if this is relevant yet. I mean, he said it in lawyer terms. So I'm going to give you a quick road so far. For all of you that are new here, we'll break down who the players are real quick. And the law nerds in the live chat will let you know exactly who everybody is if you're confused by the nicknames. We've just renamed everyone involved in this suit because, you know, we're here to break down the legal things on the YouTube, and it's a lot of fun. A reminder, when we talk about this case, we are here to talk about what the lawyers are up to, what the law says, what the legal filing says, and we are not here to talk shit about the parties involved in this case. We are here to talk about the law, to talk about what we've seen, to talk about what's happening. I know that there are polarizing creators in this case. So for those of you that are new to it, we should just do a very quick TLDR of this case. I have an entire case brief video that goes from the filing of this case in October to the end of January, but a lot has happened since January. So, TLDR. YouTube creator Tati Westbrook sued YouTube commentary channel Without a Crystal Ball, WACB, and its proprietor, Katie Joy, KJ. That happened right on October 30th. So we all started seeing this going down on October 31st up on this channel. It is at its heart a defamation lawsuit. You said this shit. I think that shit's defamatory. There's a lawsuit. There were cease and desist leading up to this lawsuit being filed. There are videos. Stuff happened. Stuff popped up on social. So on November 4th, Tati Westbrook's side filed a motion to not delete your shit. No, that's not the legal term. The legal term's a motion to preserve evidence, but the effect is the same. Filed that motion to preserve. That has since been resolved by a stipulation of the parties, an agreement between the attorneys going, hey, shit won't be deleted. It's all good. Then we actually get to the defense response. The defense filed their motion to dismiss on December 2nd. And oh, have we not lived 17 years since December 2nd, when the motion to dismiss was filed. The motion to dismiss came out hot, talking about Bye Sister, a murderous conspiracy, saying essentially Tati wrecked herself and that she also needs to sue Jeffree Star and Shane Dawson for this lawsuit to proceed. We had thoughts. There are videos. After the motion to dismiss, we got a opposition to the motion to dismiss from Saltz on December 23rd. I covered it on this channel on Christmas Eve, I think is when the video went up. That was a very long declaration. That was a very long filing with a lot of declarations. That had a Tati Westbrook declaration, a James Westbrook declaration, the Kim Fulmer declaration, and two others from Macy and Hope. That was December 23rd. It was 175 years ago. And then there was that precipice on January 4th. The precipice was the Lori-Ann Declaration. No, that first precipice was not the Lori-Ann Declaration. That first precipice was, hey, there's all these other people. KJ has a ride or die. Her name's Lori-Ann. She's a member of the channel. This is why we think there's jurisdiction in Washington. Because remember, we still haven't decided that Washington's the jurisdiction in this case, because the motion to dismiss says, hey, Your Honor, Washington's not the right place for this case. You're not the boss of us here anyway. So that January 4th, 2021 precipice was the, oh, look, there are members in the state of Washington. Lori-Ann lives in the state of Washington. There's all this information. Then there was a joint discovery stay that was filed. Like, hey, we're supposed to be exchanging information. We're not going to go ahead and do that just yet, except we're going to get to Lori-Ann's Twitter account. We're allowed to subpoena Lori-Ann's Twitter account. So that's in that beginning of January timeframe. Hey, KJ has subs in Washington. Hey, KJ's ride or die Lori-Ann is in Washington. All of this information about Lori-Ann. That was a very long, salty declaration. Then it was, hey, we're not going to exchange discovery information. We're not going to go back and forth. We're going to just get Lori-Ann's Twitter account, because at that point, Lori-Ann had deleted her social media. Then on January 6th, KJ's side, the defense, responded to plaintiff's opposition. It caught us all off guard. We're like, what? Because when the precipice was filed, they're like, hey, Your Honor, by the way, there's more shit. But wait, there's more. When the but wait, there's more was filed, Saltz said, and we agreed that Brown could have more time. And then Brown comes in hot 2 days later and is like, boom, we got your response, and filed a very lengthy declaration. And that was when KJ famously said, I do not consider Lori-Ann to be a friend at all. Not my best friend. We have limited interactions. Then there was an additional request for judicial notice. Then there was that January 9th leave to file a surreply, but wait, we'd like to reply some more from plaintiff. Then on January 13th was the Lori-Ann declaration. Tell KJ it was me. Yes, that's a tell Cersei it was me reference. That was when Lori-Ann's like, oh, you want to know who's not your friend? Okay, sure. Here's everything I know. I was an agent in the state of Washington. I had been asked by KJ to mass flag other channels on YouTube. I did this. I know her. I live in Washington. She says, Lori-Ann who? I said, Lori-Ann what? That was January 13th. Then Twitter lost its mind. There were death threats. Things happened. There were hackers. Shit went wild. On January 18th, KJ's attorney Brown filed a motion for a status conference. Mom, Salty's saying shit on Twitter. Please make him stop saying stuff on Twitter. Salty had tweeted like oh, somebody's trying to get into my accounts. This account looks familiar. Brown lost his mind. Motion for status conference on January 18th. January 21st, the court issued a minute order saying we'll have a status conference. Plaintiffs are going to file a reply. We're going to set a date. That status conference happened in February. January 22nd, defense filed a precipice. Hey, Your Honor, there's more shit. Everything in the Lori-Ann declaration's bullshit. I'll show you it's bullshit. Here's 300 pages. No, wait, that one was 200 pages. Here's 200 pages of me saying that this shit's bullshit. Okay, and emails. But not all the emails. We've since learned. There was another KJ declaration. This is now 4. Then on January 26th, the court issued a minute order saying, yes, we can have another response. It's fine. And then there was a proposed motion under seal. It hasn't affected us much because it's under seal. That means the court gets to see it. Nobody else does. On January 27th, plaintiffs filed their response to defendant's motion for status conference and said, hey, we agree that there should be a status conference with the court, but also other shit. There's so much other shit with the hacking and the death threats and the things on the social medias. That included a pretty long Saltz declaration, the Nat declaration, and the first declaration from Alana Levine, now called Queen Levine, by motion of the law nerds, motion granted by me in another live stream. Then, on January 30th, there was another precipice. On January 30th, there was also a second motion to seal. On February 1st, the motion under seal was granted. On February 2nd, there was a status conference wherein the judge, Babs, said, yo, adults, you're adults. I don't want to read your emails back and forth. What we're not going to do is this. Behave yourselves like adults. Stop it. Stop it. Stop it. And all of us thought it would stop. But that was February 2nd. February 8th, the court did the thing under seal. February 10th, there was a motion for sanctions filed by Brown. Coming in fucking hot on February 10th, going, oh, by the way, not only am I mad about what Saltzy's doing on Twitter, like I said in the status conference, but also, you should sanction him because the shit he's doing is scandalous. And we think it's, sanctionable. Sanctions for lawyers are big bombs. They're big mad with the sanctions. And that was another very long declaration from Brown saying, hey, what Lori-Ann told us is different than what she told Saltz. Sanction him. He's bad. Your Honor! Saltzy shouldn't have done that. Then, on February 15th, Brown filed a motion to shorten time on a different type of a sanctions motion. The very next day, the court said, excuse, you actually legit can't do that. There's no such thing as a motion to shorten time in the state of Washington anymore. No. And so the court struck the motion. They yeeted it. Yoded it, she yoded it. Past tense. Yoded it right out of court. No more motion to shorten time. And then because Brown wasn't done at his keyboard and apparently had nothing else to do, he filed a motion to qualify counsel on February 18th. Your Honor, can I still be KJ's lawyer? Because maybe I can't. Maybe I can't. And the central issue of that is that Brown has said, hey, Saltz et al. Have indicated that I had an attorney-client relationship with Lori-Ann. And they're indicating that if I had an attorney-client relationship with Lori-Ann, then maybe I cannot represent KJ. But they haven't brought this motion. I feel like it's a bomb over my head, and they're just going to pull the pin. That I mixed metaphors with bombs and grenades, but it's like a Nickelodeon bucket of slime, and Saltzy's holding the rope, and I'm going to get slimed in this litigation somewhere. It's going to drip down my face in green. And I would like Your Honor to take the rope away from Saltzy and say that I can still be the lawyer on this case. Pretty please, thank you. You're the best. Love you so much. That was the motion to qualify counsel. That's the response that we're here for today. But then on March 3rd, Saltz came in hot with the response to the motion for sanctions and was like, oh, by the way, Your Honor, there's some stuff Brown didn't tell you accurately. We're going to call all that out. And, Queen Levine said, I'm washing my hair. So we're busy. Lori-Ann, who's she? She's the one who signed a declaration for us plaintiffs. See, so what she told Brown is not evidence. See, because it's not a signed declaration. So Brown's trying to get the court to consider evidence that's, not evidence. And we don't think that's okay. Also, don't sanction us. Also, I had a header in that one. There's a 3-hour video. There was a lot there. But Emily D. Baker did get a header where Saltz was like, look, Brown, there's no conspiracy here. Emily just reads shit on the interwebs. And I'm like, accurate. Things get filed. We pull them up. We read them. We translate legal into curse words up in here. So today I've just downloaded the response to the Your Honor, I'd still like to be KJ's attorney. And I'm very interested to see what Saltz has to say in response to this. And you guys, it's only 17 pages. So it's going to be pretty quick. And then I'm going to get to questions. But there is one thing I want to point out because I've seen a lot of confusion around this. With regard to these motions, the attorneys always file a proposed order. Hey, Your Honor, if you do it my way, here's your proposed order. Just line out proposed and sign it. It is not a court order. It is not a court order until the court lines out proposed order and says, oh, this is the order. Those are proposed. So I know that when people look at the documents, it looks like there is an order in the file. I'm going to show you what this looks like because we're professionals, and I'm going to try to help clean this up. Clear this up, I should say. We're going to clear this one up. We're going to make it nice and big. So this is what a proposed order looks like. The proposed order, when it becomes an order to the court, will have proposed lined out right here. So this will be taken out and it will say order denying. Plaintiffs and defense put these into the record. So if the court rules one way or the other, the court just has the order there, lines it out and signs it. So this matter comes before the court on defendant's motion to qualify. In ruling on the motion, the court considered the pleadings, declarations, exhibits, and briefing, and it is ordered that defendant's motion to qualify is denied. And then if the court chooses to sign it, they put in the day, the date, and then she signs it. This is not an order. This is a proposed order. So if you see a granted order, and I can pull one up during questions if it will help. If you see a granted order, the proposed is lined out, the judge signs it. So that is how that works. We're going to read this thing through together, only 17 pages. I'm going to go ahead and pull up this. If we have to refer back to Brown's motion, I will do that after. I'm going to try to get through this entire thing without referencing back to the other motion because then it gets confusing. So it is so good to see you, Creepshow. Hello. For all of you that have super chatted, I appreciate you. Thank you. I'm going to pull them up as we get to questions. Thank you, Lawrence. Thank you, Creepshow. I appreciate you. Thank you, Marcia, so much. You guys, more motions. And look, this one is on 26-line paper. I should pull up the local rule that shows the example of 26-line paper, but we're just going to keep going. It's one way that we always know who's filing the documents. Is it on 26-line paper or is it on Emily's least favorite in the world ever, 45-line paper? So let's see. Okay. Plaintiff's response to defendant's motion to qualify. The defense has filed so much in this case. So many defense motions. And look, okay, I'm going to start now. I'm going to not pull this up yet. I'm going to go with where we're at. There are a few legal reminders that need to happen, and I forgot to do the swoosh. Swoosh! Reminders. We're not in this yet. We're still at the phase of pre-litigation where we're determining jurisdiction. The defense has not answered this case yet, which means when it comes to a motion, it's probably helpful if I just tell y'all, when it comes to a motion to dismiss, every factual inference, if there is a dispute, goes in favor of the non-moving party, the plaintiff. So even if there's a discrepancy in the shit that Lori Ann said, point plaintiff, Tati Westbrook, Saltz, because that's the stage of the proceedings that we're in. Determinations of fact go to the non-moving party. So the factual shit goes to plaintiff. It assumes everything that plaintiff says is true for this part only. It assumes everything in the complaint is true because you know what? The defendant hasn't come in and said, that shit's not true. I deny it. And when I covered the FKA Twigs Shia LaBeouf case, I know it's a joke that we say it that way. When we covered that, we saw the response. I deny this. I deny that. I deny this. I deny that. There are no denials here yet. So far, KJ has not come to court and said, this shit ain't true. All we have is this shit can't be heard in this jurisdiction. This has to go to another state. All fact goes in favor of Tati. So it's like, ooh, what's that? No, for the motion, for jurisdiction, default point to Tati. That's the stage of the proceedings we're in. I figured that that's going to come up because we're still pre-litigation. And I don't know how you determine whether an attorney can appear yet when the issues aren't even clear yet. But I said that when he filed this, and I said, I don't even know how we get to this point yet. How did we even get here? I don't know why they keep filing things. Introduction. Before defendants even have filed an answer admitting or denying any of the allegations. Oh, this feels very much like the last one. The last one started with like, well, the defense motion to dismiss is still pending. They filed a motion for sanctions. Subtext. Who even does that anyway? So this one is before defendants have even filed an answer admitting or denying any of the allegations in plaintiff's complaint, attorney Michael P. Brown and defendants are seeking a blanket order from the court that Brown and his firm cannot be disqualified now or ever as counsel in the instant litigation, quote, or future proceedings in another form. Subtext. If this shit doesn't get heard here in future proceedings, if it gets denied here, it gets refiled by Tati Westbrook in Minnesota, because that is my presumption of what will happen. If jurisdiction is not in Washington state where Tati Westbrook lives and where her company is, my presumption is that they will then file it in Minnesota where KJ lives and be like, all right, you want jurisdiction there? Fine. We'll bring it to you. We'll bring litigation to your backyard. Whatevs. We'll file it here. So he's seeking to not be disqualified in this litigation or future proceedings in another form. Read where it gets refiled if the motion to dismiss is granted. Based on his conduct related to a non-party witness, Lori Ann Barnhart. Poor Lori Ann has got to be like, I do not ever want to see my name in litigation papers again. Footnote 1, defendant's motion to qualify. Oh, good. It's a short footnote. Defendant's motion to qualify should be denied because such a motion is inappropriate. The issue of disqualification is not yet ripe. That's what I said when they filed it. Discovery has stayed. I didn't bring that point up, but agreed. The totality of the communications between Mr. Brown and Ms. Barnhart is unknown, and the requested relief is overbroad, meaning you're asking for too much up in here, boo. Nor are plaintiffs obligated to file a motion to disqualify at this point in the proceedings, meaning we don't even have to bring this shit up yet because it's too early. I mean, I don't even know how you can make this motion at this point. Defendants fail to cite any legal standard for a motion to qualify, nor do they cite a single case in which a party has successfully requested such relief from any court. I mean, I don't think it exists. Even when they filed it, I'm like, wait, you can file a motion to disqualify, but I don't think you can tell the court, hey, Your Honor, can you tell them they can't ever file a motion to disqualify? Like, I think we've never seen it done because it's not done, because it's not an issue until the people seek to disqualify you, and that's when it becomes an issue. Like, one of the attorneys would say, ooh, there's a conflict. We're going to move to disqualify you. And then you respond. Like, I've never seen it the other way around. I don't even think that's a thing. And that's what Saltzy's saying. I don't think that's a thing either. Perhaps that is because it appears no such case exists. I should just keep reading when my train of thought is the same train of thought. When I stop this 17 times and go, oh, this, and then it's literally the next line in the chat, just be like, you should just keep reading because it says it in the next line. No, I don't read ahead. I'm ADHD and dyslexic. I go line by line and give you my thoughts as they pop into my head. No such case exists, right? Because it's not done. The lack of such case law is likely because once admitted to practice before the court, attorneys are not required to affirmatively prove that they are qualified. Rather, counsel is presumed qualified and eligible to practice before this court until 1, counsel withdraws, or 2, the court exercises its duty to examine charges of a conflict of interest brought in a motion to disqualify and determines that the counsel is disqualified. Defendant's counsel, Mr. Brown, has not withdrawn and no motion to disqualify has yet been filed. Right. Okay. Footnote. Law. Plaintiffs respectfully reserve the right to timely file a motion to disqualify when the issue is ripe, meaning we're not done here, but we don't know yet, which literally, when Brown filed his motion, was in an email from Jazzy Jeff saying, we can't give you an answer because it's not an issue yet, but it could be an issue. And when it becomes an issue, we'll answer it. On January 13th, 2021, Ms. Barnhart submitted testimony against defendants' interests. Footnote 6, defendants acknowledged this conflict in the instant motion when they asserted that, quote, Ms. Barnhart's first story was plainly consistent with defendants' interest and that the signed Barnhart declaration, quote, changed that story 180 degrees. Look, when you're arguing with someone, legal, not legal, using their own words against them is a very powerful thing. We saw this in the Taylor Swift case as well. Using what the attorneys argued against them and saying, hey, you argued this, and that doesn't make sense because of this, is a very powerful argument. I will say, if you try this tactic in a relationship, it's not going to be appreciated by the other party. But it's very powerful to say, but you said. But what you said was. So, on January 31st, 2021, Ms. Barnhart submitted testimony against defendant's interest relating to personal jurisdiction, herein referred to as the signed Barnhart Declaration. She was not washing her hair that night. She signed it for Saltz, which, 1, shows that defendant Katie Joy Paulson misrepresented the nature and scope of defendant's Washington contacts in her declarations filed in support of defendant's motion to dismiss, and 2, establishes defendants have sufficient minimum contacts with Washington for this court to exercise personal jurisdiction over them. Footnotes 7 and 8. 7, declaration of Catherine Paulson. 8, declaration of Kim Fulmer. Declaration of Saltz. Those are all the different declarations. We've talked about all of them. Remember, KJ said in her declaration, I have no subscribers in Washington. And then it was like, oh, I have some. There are a few. Yeah, there's a few. Although it appears from the correspondence between Barnhart and Brown, over 150 emails and 2 phone calls, that a reasonable person would have a subjective belief that an attorney-client relationship existed, a determination of Brown's qualifications to remain as counsel in this matter due to his conduct with Ms. Barnhart is premature. Defendant's motion to dismiss regarding personal jurisdiction still is pending before this court. No answer. Correct. Affirmative defenses, other than those raised in the motion to dismiss, and counterclaims have been filed identifying the issues in this case, and discovery in this matter is currently stayed. Now, the reason that they're saying there's no issue in this case is because the defendant hasn't come in and said, that's not true. What didn't happen was this. Because the defendant could still come in and be like, I mean, some of it's true, some of it's not. The defendant could admit jurisdiction, and then the Lori Ann stuff regarding jurisdiction is rendered irrelevant. The defendant could just not answer. I mean, there's a lot of litigation to go here, which is why this amount of litigation is confusing, because there's a long way to go and a short time to get there. We're going to do what they say can't be done. Sorry. Not sorry. Let's look at these footnotes real quick. Footnote 10, see joint status report and discovery. 11, even if the court denies the motion to dismiss, the issue of disqualification nevertheless may be moot if defendants decide not to pursue a lack of personal jurisdiction defense and there is no other basis to call Ms. Barnhart as a witness at trial. Right. It's not relevant yet. It's not relevant yet. It's like your 6-year-old saying, promise when I'm 16 that you're going to buy me a car like this. Not relevant yet. Talk to me at 15 and a half. Don't come early with that shit. Likewise, until defendants file an answer and until discovery is performed, it is unknown whether Ms. Barnhart has knowledge of any non-jurisdictional issues relevant to the case. Why? Because the issues haven't come up yet, such that she would be a testifying witness as to those issues at trial on the merits. Because, look, I've told this story before and I'm going to be brief. Stuff comes up at trial that wasn't a big deal and all of a sudden is the big deal. There was an arson case I was involved in as a law clerk, and while people were testifying, it became very relevant that this like one particular thing was like all of a sudden very, very relevant based on what witnesses said. But the witnesses hadn't said that before. The witnesses on the stand were like, oh, but I also remember this. And everybody was like, you remember what? Hold on. And I was like trying to track down other witnesses and information. And I got the information from the investigator through the fire department. Great dude. Absolutely adored him. Loved working with him the most. Hi, Detective Wills. And was like running down the hallway to court, go into the courtroom, up to the prosecutor, who was amazing, and was like, by the way, we found the person that you were looking to find. You need to interview them after lunch. You're going to need to ask the court for an extended lunch. They're sitting in your office. You might want to tell the defense attorney that there's new discovery, like right now, since your jury's sitting literally right there, because we're on the record. Okay, cool, thanks. Stuff becomes relevant in cases that you cannot conceive of based on other shit that happens in cases, which is why there is no way the court can grant this motion, because there's no way to know what could become relevant. Additionally, the court does not have all the facts to affirmatively and indefinitely qualify Mr. Brown as counsel, because it's clear that Lori Ann's information and KJ's information don't line up. It's not beneficial. KJ said, I have no subscribers in Washington. Lori Ann said she has some. KJ says, I never ask anyone to do things for me. Lori Ann said, well, actually, you kind of asked me to do these things. There are differences there. And if Brown represented Lori Ann and gave her legal advice, which is the argument here, then that's a problem if Lori Ann becomes a necessary witness. Although Mr. Brown has provided the court with a compendium of his email communications with Ms. Barnhart, he has not represented that he provided this court with all his communications with Ms. Barnhart. To be certain, Ms. Barnhart provided plaintiff's counsel with additional communications that were not in, that were not in Brown's numerous declarations. I didn't even think of this when we were going over the other ones, but with regard to this motion too, Brown said, you've seen everything. And Saltz saying, actually, oh no, he didn't. They're not saying he said you saw everything. They're saying you saw my communications, but he didn't say these were every communication. So it's like, well, actually, there's more? But wait, there's more. Did I miss a footnote? I did. Nope, we got that one. 12. See Brown supplemental declaration. And we never miss a sassy footnote. Look, law students, wannabe law students, thinking about law school. Bailey Sarian, thinking I want to be a lawyer. All of you, read the footnotes always. You know that scene in Legally Blonde where she's sitting there and he's like, oh, for this professor, always read the footnotes. That's where he gets his exam questions. Always read the footnotes. Always read the footnotes. Okay, footnote 13. Plaintiffs identified at least 2 emails between Brown and Barnhart that have not been filed with the Brown declaration. Declaration of Queen Levine in support of plaintiff's opposition to defendant's motion for sanctions. So it's like, oh, by the way, Your Honor, they're over there. The other emails are in the declarations. Here we are. Thus, neither the court nor plaintiff's counsel can fully evaluate Mr. Brown's relationship. I was going to say representation. That's not what they said here. Brown's relationship with Barnhart without all the necessary information. So Saltz et al. Is saying, but wait, there might be more that actually shows he was Lori-Ann's lawyer. The fact that it's this much of a question about whether he represented her or not is troubling. There is no question that Brown now has a conflict of interest regarding Lori-Ann. The record reveals that Brown has repeatedly attempted to discredit Lori-Ann's testimony, truthfulness, mental capacity, despite his own efforts to use Lori-Ann for her testimony on behalf of defendants as recently as 2 days before the signed Barnhart Declaration was filed, which is well taken. Footnote 14, see Brown Supplemental Declaration, January. Oh, these are from the emails. I love it when they're summarized. January 11th, 8:02 a.m. We will be filing an objection today, and I'd like to include a statement from you if you are on board with that. January 11th at 9:10 a.m. I'd like to stand up for you by filing your declaration if you'd let me. January 11th at 3:16 p.m. We're filing something today that addresses the threats Saltz made to you. It would be great. Oh, my favorite line. It would be great if you could state that you took it as a threat and felt intimidated. Okay. Finally, defendant's motion to qualify relies on hearsay evidence. 15. Defendants cannot raise new admissible evidence in their reply. I said this when they filed their reply and added much better arguments, more case law, and more information. However, you've got to do that in your motion when you're the moving party. We talked about that. Because look, the motion to dismiss, hot mess. The opposition, strong. The reply from KJ's side, much better. The reply to the opposition had better arguments, more research, and it was much more clearly written. However, you can't bring up new shit in the reply. It has to be in your motion. See, because you're in charge of your motion. It has to be in your motion. I'm doing this so much that my camera's shaking. We're gonna try to settle her down. We're gonna settle her down. Defendants cannot raise new admissible evidence in their reply. And then there's law, and then they cited all the law. Finding that counsel may not decline to submit declarations to support a motion and then in reply provide declarations that counter opposing parties' argument with the new allegations. That's literally exactly what happened in this case. Oh, there's a case on point. Gotta love a case on point. Goldman's versus Insinger. That's a fun last name. Counsel may not decline to submit declarations to support the motion and then in reply provide declarations. Literally exactly what happened in this motion to dismiss. And Lori-Ann's stuff's all hearsay anyway. 1, Mr. Brown's correspondence with Barnhart, and 2, Mr. Brown's correspondence with purported relatives of Miss Barnhart. In light of these issues, plaintiffs were not and are not in a position to stipulate to Mr. Brown's request to retroactively remedy his conflicts of interest with his former client, Miss Barnhart. 16. Brown also mischaracterizes plaintiff's counsel's position and statements during the meet and confer on the motion to qualify and fails to inform the court that plaintiff's counsel told Mr. Brown, 1, his mischaracterization was not plaintiff's counsel's, quote, recollection of what was said during the call, and 2, plaintiff's counsel's recollection was that what plaintiff's counsel represented was that this is why the court said what I don't want to do is go back and forth with all of these emails, because trying to even explain the back and forth makes my head hurt. Plaintiff's counsel's recollection was that what plaintiff's counsel represented was that they didn't intend at that time to make a motion to the court on the issue, which was literally what was in the email that we all read together up on this channel. Footnote 16. We did footnote 16. In light of these issues, we did that. For the same reasons, this court should deny defendant's motion to qualify. Clarification of facts. Subtext. Shit we think you got wrong. Communications between Lori Ann and Brown. The reason, by the way, that KJ's side is going so hard on this is because the Lori Ann declaration makes it hard for them to win the motion to dismiss, in my opinion. And if it didn't make it hard for them to win the motion, why would they spend all of this time filing all of these motions about it, trying to get it thrown out? Why? They wouldn't. Communications between Lori Ann and Brown. Beginning on December 24th, 2020, Brown and Barnhart proceeded to exchange nearly 150 emails and 2 short phone calls over the course of 18 days. None of these communications established that Brown advised Lori Ann in writing that he did not represent her and that he was not providing her legal advice. The nature of the approximately 150 emails has been produced by Brown to reveal that he provided Barnhart with legal advice relating to 1, alleged harassment she received on Twitter following the filing of the Fulmer Declaration, 2, how she should respond to plaintiff's proposed subpoena, and 3, her proposed testimony in support of defendant's motion to dismiss in this matter. Additionally, the primary reason Barnhart contacted Brown was to solicit his services to correct the record as to her employment. So let's go hit footnotes 17 and 18. 17 just cites to where it was in Brown's motion. 18, see Brown supplemental declaration, docket 43-1. I hope that the other Lori Ann isn't being harassed. Look at what they've done to me and the other Lori. Will anything be put out so this woman's information will stop spreading? I contacted you because of the doxing of the wrong Lori. Do they know I'm not the other Lori yet? I think they still believe I am the other Lori. Do they know I'm not the other Lori? They can show up at Lori's house or work, harass her and her family now too. Can you tell me what is going on with the other Lori? Again, the issue seems to be that Lori Ann Barnhart went to Brown and said, yo, the Lori Ann Barnhart that's identified in this declaration is not me. And I don't want my behavior in the online space to cause people to harass the other woman by the same name, because now her place of work has been disclosed and connected to me. And I don't want people emailing this woman at her place of work being like, you acted like a jackass up on Twitter and I've got something to tell you about it. Because trust me, there are times when people don't like what you do on the Twitter, they will go ahead and email you. Spoken from experience. But it's fair. So it seems that Lori Ann went to Brown saying, can you make them fix this? Tell them it's not me. And then Brown went ahead and didn't do that. And then Lori Ann went ahead and said, I think you're a slime ball, and called Saltz. And that seems to be the fact pattern of what happened there. In the signed Barnhart declaration, Barnhart testifies that Brown offered to represent her as a third-party witness in this litigation. Footnote 19, see signed Barnhart declaration, see also Brown declaration. Quote, I'd like to stand up for you by filing your declaration if you'd let me. It costs you nothing. What do you all think? What would you take away from that? When a lawyer says to you, I'd like to stand up for you by filing your declaration if you'd let me, it costs you nothing. What do you think? What would you think if you were on the receiving end of that email? Would you think, hey, this is getting me, hey, you're giving me advice? Hey, you're standing up for me in court? Let me know what you think. Barnhart also advised plaintiff's counsel on January 12th, 2021 that she believed that Brown was acting as her attorney because she repeatedly asked him for legal advice, which he provided. Footnote 20, See Levine declaration. Barnhart, quote, figures, what are your thoughts? See also Brown supplemented doc. That was Barnhart responding to Brown saying, yeah, it figures. What do you think? Barnhart, is there anything I can do or should I try to ignore it? Mr. Brown, I'll have to think about this. For the time being, it's best not to make any contact with Katie and vice versa. They are working hard to try to paint you two as a team, and that's not good for either of you. Well, I think it's worse for KJ, my opinion. Miss Barnhart, don't worry. I will not say or do anything without telling you first. Does that sound like somebody who's going, okay, I won't do anything with regard to any of this until I run it by you? Why would she say that? Unless she thought he was telling her how she should behave in all of this. Again, not fault to Lorianne. Brown is the lawyer. The lawyer has to do what's right. We all know how I feel when they don't. Brown, you have a right to object to the subpoena. At a minimum, that would delay everything, and the judge might just say you don't have to respond. Brown, you have done, there's a lot more of this. Nothing illegal. I recommend that you sit tight. I recommend. Accept service if they come to your door, and then we can take it from there. Barnhart advised plaintiffs that she believed Brown was acting. Okay. And he offered on multiple occasions to help her at no cost. Footnote 21. Didn't we just read that? Levine declaration. Mr. Brown, do you have the ability to pay your own lawyer if they do issue a subpoena? Mr. Brown, I can help with that. Mr. Brown, you don't need to spend money or hire a lawyer to respond to the subpoena. Mr. Brown, I can give you some assistance with respect to responding to the subpoena. Mr. Brown, I think I can help with the response for no charge. It's very simple. Well, when it's all laid out like that, you're just like, oh, those are a lot of statements over email saying, can you get a lawyer? I can help you. You don't need to spend money to respond to a subpoena. I can give you assistance. This is not hard. Well, it's not hard if you're a lawyer. Mr. Brown also dissuaded Barnhart from contacting plaintiff's counsel directly. For example, on December 30th, 2020 at 5:55 p.m., Brown wrote, I spoke with Saltz today. They're planning to subpoena your Twitter account. Right, because Saltz thought that Brown and Lorianne, Saltz thought, based on his declarations, that KJ and Lorianne were having conversations. And since Lorianne had been a paid member and Lorianne was in Washington, they thought there was some agency between the two of them showing that there should be jurisdiction. And then Lorianne's Twitter went gone. It was deleted. So there was concern that, look, if KJ and Lorianne are having all these DMs back and forth regarding like flagging channels or things with this case or anything, then there is this connection to Washington, and her Twitter had been deleted, and then the, DMs can disappear. And now we know they've had Lorianne's Twitter, and we know they've seen all the DMs because they spelled that out in the last motion for sure. They were like, yo, here's all of Lorianne's DMs. We've seen them. We know the conversations. They are planning to subpoena your Twitter account. I should have just kept reading, because they see that you closed your account and they think there might be evidence there about your connection to Katie. Yes, they thought there would be DMs. Why? Because there were screenshots from a KJ live stream where you could see that she was DMing with Lorianne. I did not disclose that you and I are in touch. Saltz even complained to me that you, quote, threatened him via DM. Subtext. That was subtext. Footnote 22, Brown, just where it was. At 6:18, Barnhart responded, figures, what are your thoughts? 23, notably, this email was not provided by Brown in the multitude of his previous filings with the court. There it is. Her directly asking, figures that he complained to you, eye roll, what are your thoughts? You working with me, what should I do? It's interesting to me that email wasn't included. What do you think of that email not being included? Is it forgotten? I mean, we went through the 300 pages of that declaration and emails. Was it forgotten or was it omitted. 6:22 p.m., Brown responded, I'll have to think about this. For the time being, it's best for you not to make any contact with Katie and vice versa. They are working hard. Lawyers speak, for they are stretching. Also, if there's a screenshot that y'all are DMing, I don't think it's a stretch. My opinion. They're working hard to try to paint you two as a, quote, team. That's not good for either of you. Though team might be a stretch, but now they've seen the DMs. And apparently there were hundreds of connections between the two. 7:16, Barnhart responded in relevant part, maybe it would just be easier if I went ahead and met with Saltz myself. He can see me face to face and see I'm no threat and I have nothing to hide. I actually present myself very well and know how to be professional when I need to be. Subtext, I know I can be a jackass on Twitter, but I can also just have a conversation. Don't worry, I will not say or do anything without telling you first. I want to talk to the other attorney, but I won't do it if you don't want me to, and I will not make a decision without running it by you. I won't make a decision without running it by you because I feel like you and I are making decisions together. Why? Because I perceive, this is Emily speculation, I perceive that you are my attorney. That is why I perceive that we are working together in making these decisions. And that perception can be enough. On December 31st, Mr. Brown wrote, I understand that impulse, but you need to understand the type of person he is. Subtext, Saltz is a dick. Don't talk to him. Saltz is a dick. Do you have the ability to pay for your own lawyer and help if they do issue a subpoena? It is unclear if Ms. Barnhart responded to the above email as the record is devoid of such response, yet December 31st, 2020, Brown wrote, you'll get a copy of the subpoena if they issue it. If it just asks for communications with Katie, then it sounds like there won't be much of it. Now we know that that's not exactly accurate. If it's too broad, like asking for all your tweets, etc., you can challenge it. Advice. Footnote 27 just cites where it is. See, all these sites are like, hey, Your Honor, it's at this record. It's on this page. It's on these things. Mr. Brown also convinced Barnhart on at least one occasion that she did not need to consult with separate counsel. Yeah, that made me go, when we read it originally. On January 8th, 2020 at 5:35 p.m., Barnhart wrote in relevant part, I used to volunteer for Snohomish County Legal Services. Maybe they can help me. Brown responded, what help do you think you need? From legal services. Barnhart wrote, advice. Brown wrote, I understand. You really have nothing to worry about with this. You've done nothing wrong, which I agree with, by the way, but also that might be advice. I think I can help with the response for no charge. It's very simple. As opposed to saying, I used to volunteer for county legal services, maybe they can help, and be like, if you feel they can help, then maybe you should talk to them. Oof. 28, notably, Snohomish County Legal Services is a free legal aid program. Thus, Mr. Brown's attempt to explain that his statements to Ms. Brown were not to reassure her that she did not need to spend money in responding to the subpoena is misleading. Oh, so what they're saying is that Brown said, I was assuring her she didn't need to spend money. And Saltz is saying, right, but that's free legal services because that's county legal aid. So you didn't need to reassure her she didn't need to spend money because she could have gone and gotten advice without spending any money at legal aid, which I forget that when I started law school in Washington, but when I read county legal services in my mind, I know what that means. So they spelled it out more clearly. The court may take judicial notice of this fact because it is a fact not subject to reasonable dispute and available from a reliable source like the county website and the county courts. The court will probably know that anyway. The court can take, and then we get into judicial notice. Like the court can say, yes, it is free. On or around January 11th, 2021, Ms. Barnhart terminated her attorney-client relationship. Over under on whether the slime ball comments in here at least once, if not more than once. Let me know, because I'm betting that's what comes when we scroll this page. It's going to be like, I see who the real is. Was it slime ball? Was that the exact words? I see who the real slime ball is. I think that's what's going to be next. Let's just sneaky peek. Let's just sneaky peek. It's going to be in here somewhere. Or at least I hope it's going to be in here somewhere. Maybe I'm wrong. Terminated her attorney-client relationship with Mr. Brown, footnote 33. See signed Barnhart declaration of Saltz in support of plaintiff's motion. Good luck with your case. Brown supplemental declaration. Unfortunately, I see who the slime ball is now. We have reached slime ball. Okay, well, that's once. Let's see if it comes up again. That was footnote 33. And on January 13th, the signed Barnhart declaration was filed. So January 11th, she's like, I see who the slime ball is. Then she called Saltz. Then on January 13th, they signed the corrected declaration. On January 22nd, 2021, Brown filed a supplemental declaration in support of defendant's motion to dismiss, in which he purports to characterize his communications with Ms. Barnhart and accuse Ms. Barnhart of filing false statements under penalty of perjury. Right. Footnote 35. Oh, good. It just cites to where it's located. Mr. Brown also attached, quote, the relevant emails with Ms. Barnhart, nearly 200 pages for public review and consumption. And didn't we, though? Didn't we review? We reviewed. We've reviewed and we've referred back. Mr. Brown withheld, quote, those containing especially sensitive health information and purported to provide such emails in his second supplemental declaration. Was that a supplemental or was that a sealed? The second supplemental declaration filed under seal, 10-4. It remains unclear whether all of Mr. Brown's communications with Barnhart have been provided. I'm live. You can say hello. I'm not recording. I am just live.
Hi.
Hello. Hello. Did you want to talk about YouTube Shorts more? We can talk about YouTube Shorts when I'm done.
I had an idea for public opinion, and I wanted to talk to you.
Okay. When I am done, we will talk about your idea for court of public opinion. High five.
Okay. Can I tell you now? Or no?
Tell me now. You can whisper it. But if it's going to be court of public opinion for tomorrow night, I don't want them to know because it's a surprise for tomorrow night. You can't control yourself. You could have texted me. That's a good question for court of public opinion. I love you. I will see you in a minute. You can also text me so I don't forget because ADHD. Okay. Oh, 13. You could go ahead and close my door too. All right, let's get back into the argument because that's where we landed. Everybody say hi to T. He's started making YouTube Shorts. He's very excited about it. He posted his first one yesterday. So that is T. Thank you all for the birthday wishes for him. He is a really fun kid. So thank you all. Argument. Motion to strike. Can we call motion to yeet? Motion to yeet. Motion to yeet. Defendants again rely on hearsay evidence and 3 unsigned declarations prepared by Brown, collectively unsigned Barnhart declarations. This is why this is shade. Barnhart's unsigned declarations in Brown's motions are called the first Lorian declarations. Like, this is the true tea. These are the real deal. So then when Saltz refers to them, he does not refer to them by first and second. They refer to them by unsigned, not evidence, and signed, evidence. And so everyone is doing their own thing to make sure that the court knows how they feel about it. So even the way the lawyers refer to these declarations is advocacy. So the advocacy from Brown is the first one, subtext, the real one. That one's the fake one. Salty sucks. He's bad. That one's fake. Ours is real. Meh. And for Saltz, it's ours is signed. Ergo, ours is under penalty of perjury. Ergo, ours is evidence. Theirs is unsigned. Theirs is bad. They suck. It's not real evidence. So that's what it is. You guys, there are almost 7,000 law nerds in here. Could y'all go ahead and do the YouTube things and like the stream and stuff while you're in here? I would super appreciate it. That would be the best. Thank you so much. So if you could go ahead and just do the YouTube things. Oh, and if you're not subscribed, we're pushing towards 100K. Diane Hair Purple. It's a thing. We're at 90.3. So if you aren't subscribed and you could just subscribe, that would be great too. Thank you for doing YouTubey things. Unsigned Barnhart Declaration. Not evidence. We'll talk about evidence class. Okay. Motion to yeet. Defendants rely on hearsay evidence. Hearsay is not admissible for the truth of the matter asserted. 3 unsigned declarations prepared by Brown, collectively unsigned declarations to support the instant motion. 39 plaintiffs previously moved to strike this evidence in their opposition to defendant's motion for sanctions pursuant to Local Rule 7G and FRE 801 and 802 and the local electronic filing procedures. Plaintiffs reiterate their motion to strike. 40. And then they cite where it is and say, although Ms. Barnhart's own prior statements may be used for impeachment purposes on cross-examination if Ms. Barnhart testifies at trial, such evidence is inadmissible to support a motion. Right. Because it's hearsay. And you can't, look, when it comes to like prior statements, prior inconsistent statements, impeachment evidence, the person has to be testifying for it to be relevant. There is no issue of fact now because this is a motion to dismiss. So there's no issue of fact because if there is an issue of fact, it goes to the plaintiff. It just defaults to the plaintiff. So you can't submit hearsay and say, yeah, but she said something different earlier. She's not testifying. And she's not a party opponent. She's a witness. There are rules. Society has rules, people. Oh, there's more to this. Okay. I ranted early. There's still more. On a motion to dismiss for lack of personal jurisdiction, the court does not weigh the credibility of witnesses and factual disputes are resolved in favor of the plaintiff. See, how many times have I said I should have just kept reading? This says what I say. Because here's the thing. The rules of hair care are simple and finite. And so it's easy to predict what's coming next when it follows what the law is. And what the law is that shit's hearsay. Because it is. Although potential conflict of interest and ethical issue plainly exist. Ooh, they're just going in on this heading. Although that shit's problematic, disqualification is not yet ripe. This shit's problematic, but also we can't get there yet. Attorneys practicing in the Western District of Washington, I don't know why I can't say my words today. Western District of Washington must abide by the rules of professional conduct. Oh my God, how much have we heard about the RPC? We've heard so much. The RPC first came up when KJ was like, Saltz, you're violating the rules of professional conduct, and like went in on Twitter. Meh. And now we're here still talking about the RPC. Look, professional conduct is important. Do not judge the way that attorneys are treated by what you're seeing in the Girardi case. That's an anomaly. Normally, this shit's taken really seriously. The court retains responsibility for controlling the conduct of lawyers practicing before it. Non-client litigants may, under proper circumstances, bring motions to disqualify counsel based on conflict of interest, where an unethical change of sides was manifest and glaring, or an open and obvious ethical violation which compels the court to exercise its plain duty to act. Let's look at the footnotes. These are all case cites to law. Like the law is all here. Once again, when you are a law student or a clerk or learning the law and you're trying to figure things out, knowing where they're getting the law from is super helpful, which is why they put exactly where they're looking for the law. These are all the sites. And it makes it really helpful to go through and be like, oh, you can play along at home. This is what they're looking at. Brown's disqualification is not ripe. That shit's not relevant yet. Ripe like a fruit, right? You don't want to squeeze the unripe fruit. I mean, maybe you do. That's a horrible I don't know where that analogy was going. Just motion to strike, terrible analogy from the record. Motion granted. Fantastic. Moving on. While a motion to disqualify counsel ultimately may be necessary, defendant's instant motion to qualify is premature as well as improper. Yes, it's not ripe. As the requested relief that the court enter an order finding that no grounds exist to disqualify Mr. Brown and his firm is overbroad. Defendant's effort to prematurely obtain a ruling on Mr. Brown's disqualification due to alleged concerns about plaintiff's use of the issue as a litigation tactic, the holding the rope with the slime litigation tactic, are misguided and fail to show ripeness. Not juicy yet. Contrary to defendants' assertions, defendants are not being, quote, forced to proceed under the constant threat that plaintiffs will choose some strategic time in the future to make the motion to yeet. Rather, it is Mr. Brown's actions that have created the situation in which defendants find themselves, and it is defendants' motion to dismiss and their agreement to stay discovery that make the disqualification not ripe. So, if you agreed to jurisdiction, maybe we could address it. But you didn't, so it's not ripe because everything still goes to us. Moreover, Washington law prohibits the use of motions to disqualify as litigation tactics. Oh, so you can't even do that anyway. So he's arguing shit that actually can't be done. I want to know how. I want to know why. Moreover, Washington law prohibits the use of motions to disqualify as litigation tactics. Kind of like Washington law, bars the filing of a motion to shorten time. A motion to disqualify must be filed with reasonable promptness after a party discovers the basis for an alleged conflict. The failure to do so may result in waiver of the objecting party's ability to bring the motion. If you wait to spring it on somebody later, the court can say, boo, that's not it. Yeet. Delay in filing a motion to disqualify is suggested of its use for purely tactical purposes and could be the sole grounds for denying the motion. So if the court said that you're doing this to fuck with the other side, the court can say, no, you're not doing that. You have to bring it when it's an issue. And if you wait to bring it, out. Cites to law. In FMC Techs Inc., the court said finding no undue delay for 6-month gap between beginning of the lawsuit and filing a motion to disqualify because the issue of disqualification was not ripe until the district court denied defendant's second motion to dismiss claims seeking to rely on the testimony of the former client. So something happened and made it ripe. Case law is so helpful. Here, so wait. Brown is the expert in Washington. Brown practices in Washington. Brown is local counsel in Washington. So are you telling me that Brown knew that his argument was in direct conflict with the settled state of the law in the state where he practices? What this indicates is that in the state of Washington, it is settled law that you cannot use this as a litigation tactic. But Brown argued to the court that Saltz was using it as a litigation tactic. Why would you try to convince the court that Saltz is using it as a litigation tactic when you know that the law says, but you can't do that? Why would you make that argument? Why would you make I don't understand. Because knowing the settled state of the law is just going to annoy the judge going, but you're arguing to me something that legitimately cannot happen. You're arguing shit that can't take place. Oh, like that motion to shorten time that you legitimately cannot file. I have so many questions. Why are we playing with the money? This is just setting money on fire, these types of arguments. Here, Plaintiffs have not delayed filing a motion to disqualify because the disqualification issue is not yet ripe. Plaintiffs first became aware of a potential issue on January 12th. What day is it even? March 11th? They're like, it's been a motherfucking month. We don't even know if this person is a witness for anything other than jurisdiction. And once jurisdiction's settled, it's not necessarily relevant. Which was after Brown's motion to dismiss was filed on December 2nd. Depending on the court's ruling on the motion to dismiss, defendants' litigation decisions, what the defense chooses to do, i.e. defendants continue to pursue jurisdiction, and on what defendants put at issue in their anticipated answer, assuming defendants file an answer. Mr. Brown's qualification or disqualification as counsel in the matter may be rendered moot. 49. Finding no issue. Oh, we already went over that one. Finding no issue of undue delay. Additionally, discovery has been stayed in this matter until the court rules on the motion to dismiss, and until discovery is conducted, plaintiffs cannot ascertain whether Barnhart would be a testifying witness regarding jurisdictional and or non-jurisdictional facts. Fair. Or whether Mr. Brown is in possession of a proper written conflict waiver signed by defendants and Ms. Barnhart contrary to her testimony. So if Brown says everything Lori Ann says is bullshit, and Lori Ann says there's like no conflict waiver, could Brown come in and be like, there's a conflict waiver? And if he has a conflict waiver, why didn't he just say, I have a conflict waiver? But if he had a conflict waiver, would he file a motion to qualify counsel that seemingly can't be filed? Because he would know that he could be qualified because he had a conflict waiver. What's a conflict waiver? Excellent question. I should explain myself. It's when an attorney sits down with a person and says, here's the potential issue. We cool? Sign it. I mean, it's more detailed than that, but you know what I mean. Therefore, the disqualification issue is not ripe for consideration. In addition, even if the disqualification issue was ripe for consideration, a delay of less than 3 months while discovery has been stayed. Why discovery being stayed is a big deal. When discovery happens, both sides will exchange information that they have. So more information may come up. More may become apparent to both sides. So Saltz is like, look, stuff may come out in discovery where we need to know what Lori Ann has to say about it. Stuff may come up where she is a necessary witness, but we can't know what we don't know because we don't know because we haven't done discovery because we all agreed to stay discovery. And no substantive motion practice has occurred or can occur until the court rules on the motion to dismiss. Like, this is way more motions than you would see or should see before the court has said, yes, I have jurisdiction. That's not unreasonable grounds for delay. Brown and Barnhart appear to have formed an attorney-client relationship. We've talked about this so much. An attorney-client relationship exists when the conduct between an individual and an attorney is such that the individual, Lori Ann, subjectively, Lori Ann, believes such a relationship exists. So the emails from Lori Ann indicating what she believed become very relevant. Does she think she's represented? Not what Brown thinks. Does she think? The client's subjective belief, however, does not control the issue unless it is reasonably formed based on the attending circumstances. So now let's look at the emails. Because if somebody's just like, no, I saw them on the street, I wanted them to be my lawyer, like, they're my lawyer. Like, if Kanye West sells merch that says, Kim's my lawyer, to everyone, and somebody buys that sweatshirt that says, Kim's my lawyer, and then they go to court and say, but Kim was supposed to show up, Kim's my lawyer, I have a sweatshirt. The court's going to look at it and be like, there's no action here. We've got to still look at the action. Here, the court's going to look at the attorney's words and actions. A court must have the facts of what actually occurred. Emails is helpful between two parties in order to determine the legal question of whether the parties established an attorney-client relationship. So was it reasonable to think that? An attorney-client relationship may be implied from parties' conduct. It need not be memorialized in writing. There doesn't have to be a signed agreement going, you're my lawyer, but the writing back and forth can establish it. Washington courts have held that even a short consultation, meeting, or conversation may create an attorney-client relationship. This is why attorneys get hesitant to answer questions on social media, on Quora and things like that. These all cite to law and cite to the different declarations. Here, Ms. Barnhart testified that she had an attorney-client relationship with Brown. Defendants even sought sanctions against plaintiff's counsel for violating RPC 4.2 when they spoke with Barnhart. See, it's gonna come back to bite you in the ass. For everybody who's like, what the fuck did Emily just say? Here's what it is. Brown, in the motion for sanctions, one of the arguments was, okay, if you think I represent Lori-Ann, you should be sanctioned for speaking to her, indicating that Brown thinks that it's reasonable for someone else to believe that there was an attorney-client relationship. Therefore, he asked to sanction Saltz for talking to Brown, no, Lori-Ann, because she was represented. So Brown wants the court to punish Saltz for talking to Lori-Ann because he thinks there's enough there that Saltz could believe that she was represented. And then he says, but she's not represented by me. But he should be sanctioned because it looks like she may be represented by me. Again, using what was said in the motion to come back around. Additionally, Brown advised the court on more than one occasion that he and Barnhart exchanged nearly, quote, 150 emails and 2 phone calls over the course of 18 days. Oh, it was said so fucking much. It was said so much. It was said so much. It was said like 175,000 times during that motion. That's an exaggeration. But only just barely. While Brown only cites 2 emails to and from Brown in the instant motion to qualify, the breadth and nature of the available correspondence as a whole appears to support Barnhart's reasonable belief that Brown represented her. For example, the available correspondence shows that 1. Barnhart repeatedly requested Brown's legal advice, and as early as December, told Brown she would, quote, not do or say anything without telling him first. 2. Brown repeatedly offered her legal advice. 3. Brown actively dissuaded her from contacting plaintiff's counsel, I would say, or other counsel, directly. Barnhart indicated that Brown on at least 4 occasions that she was inclined to contact plaintiff's counsel directly. However, Brown convinced her not to do so. And you know why Brown convinced her not to do so, in my opinion? Because if Brown had allowed Lori-Ann to contact Saltz, she would have said, I don't want any part of this shit. Here's my Twitter account. And the Twitter account would have showed the depth and breadth of her conversations with KJ, which are directly against KJ's interests, which is why there's a conflict in the first place. Because Lori-Ann's interests are get me the fuck out of this thing. Stop the ride. I want to get off. Oh my God. I want to get off. Stop the ride. Take my Twitter. Jesus, let me go. Like, Jesus, take the wheel. Stop the ride. Let me off. And KJ's interest is don't see what I was talking to Lori. Lori's in Washington. It could be a matter of jurisdiction. Lori just wanted off this ride from the fucking beginning. Based on the preceding examples alone, Barnhart's subjective belief that an attorney-client relationship existed with Brown appears to be reasonably formed, not without basis. Barnhart terminated such attorney-client relationship on January 11th, 2021, footnote 66. Darn it, it doesn't say slimeball again. Brown supplemental declaration, quote, I understand that impulse, but you need to understand the type of person he is. Subtext, I think Saltzy's a dick. Can you please talk to me before you do anything? I understand this is very stressful. Oh, that was 65. Oh, whatever. You should at least speak to me about it. 66 probably goes back to the line where it says slimeball, but it doesn't say it again. They could have probably said it again. Would that have been too much? It might have been too much. I mean, it might have been too much. And so these are footnotes to all of the emails that we have already talked about repeatedly. Do they know it's not the other Lori Ann yet? Do you have the ability to pay for your own lawyer? I recommend that you sit tight. I can give you some assistance with that. Have you been served? Maybe it'd be easier if I went and met with him. All of these are those emails we've read. At the very least, Brown and Barnhart formed a prospective client relationship. Even assuming Brown and Barnhart did not have an actual attorney-client relationship, Barnhart appears to be at the very least a prospective client who Brown owes certain duties. Rule 1.18 Washington RPC, which establishes duty owed to a prospective client, is the applicable rule here. The rule provides in relevant Part A, a person who consults with a lawyer about the possibility of forming a relationship with respect to a matter is a prospective client, even when no attorney-client relationship ensues. A lawyer who has learned information from a prospective client, this is the kicker, shall not use or reveal that information. So any information Brown got from Lori Ann, Brown can't turn around and use the information he got from Lori Ann against Lori Ann if she testifies. Like in the declarations that he solicited from Lori Ann, that he's turning around and saying, what she said, what you say, she is unstable and she told me things, and Saltz's declaration is not true. A lawyer subject to paragraph B shall not represent a client with interest materially adverse to those of a prospective client in the same or substantially related matter, meaning, KJ, related matter if the lawyer received information from the prospective client that could be significantly harmful to that person in the matter, except as provided in paragraph D or E. If a lawyer or LLT is disqualified from representation under this paragraph, or paragraph C, LLT RPC 1.18, no lawyer in a firm with which the lawyer or LLT is associated may knowingly undertake or continue representation in such matter. Here's what that means. If Brown is disqualified under Washington rules, his entire law firm is disqualified. Comment 2, RPC 1.18 states, whether communications, including written, oral, or electronic communications, constitute a consultation depends on the circumstances. For example, a consultation is likely to have occurred if a lawyer, either in person through the lawyer communications in any medium, specifically requests or invites the submission of information about a potential representation without clear and reasonable, understandable warnings and cautionary statements that limit the lawyer's obligations. Remember, this is commentary, not legal advice. Disclaimer, just because we talk does not make us people. Those types of things. And a person provides information in response. In contrast, consultation does not occur if a person provides information to a lawyer in response to a communication that merely describes the lawyer's education, experience, areas of practice, contact information, or provides legal information of general interest. So if you email a lawyer and spill your life story, it does not mean that they have solicited you as a client, etc. Here, Brown and Barnhart exchanged nearly 150 emails. Oh my God, we're going to say it so much. Nearly 150 emails over the course of 18 days. At no time has Brown submitted to this court evidence or argument that he sent an email to Barnhart that contained any clear and reasonable, understandable warnings and cautionary statements. Yeah, there weren't any emails that said, disclaimer, I'm not your lawyer. Do you understand? I'm not your lawyer. We're talking about shit. I'm KJ's lawyer. I'm not your lawyer. I don't represent you. I don't stand up for you. I don't fuck with you. I'm not your lawyer. But I can say if a subpoena comes to your house, just respond to it. And if we need to get you a lawyer, we will. I want to see legal disclaimers that say that at the bottom. Just because we speak doesn't mean I fuck with you. Like, that should be the new disclaimer. And if that disclaimer existed, where is it? Because that would make all of this go away. Okay, page 14 of 17. We're getting there, folks. We're getting there. Instead, Brown made numerous requests and repeatedly invited Barnhart to submit information about herself and the matters at hand. Those are all sites. Ms. Barnhart disclosed substantive and confidential information to Brown that could be significantly harmful to her. 69, that is the second. So that's the stuff under seal. So now what Saltz is saying is, hey, there's stuff that's so personal that this court granted a motion under seal so that others wouldn't see it. She gave him substantial personal information. Oof. Mr. Brown, therefore, may be barred from using Barnhart's confidences against her and barred from representing defendants who have adverse interest in the same matter. The record reflects a significant conflict of interest. So this is going to be why they think there's a conflict. While plaintiffs have not yet moved to disqualify Brown and his law firm due to the disqualification issue not being ripe, it is apparent that a conflict exists. Mr. Brown asserts that his communications with Barnhart were for two purposes. One, to explain the abusiveness of the Fulmer Declaration, which was submitted in support of the opposition of the motion to dismiss. Don't say that 10 times fast. Two, to confirm defendants' statements that they did not know Barnhart resided in Washington until the fact was disclosed in this lawsuit. However, Barnhart's testimony states, among other things, one, Fulmer's declaration was accurate, with the exception of where Miss Barnhart allegedly worked. Two, Defendant Paulson did in fact have reason to know that Barnhart resided in Washington by at least April 2020, if not earlier. Three, Defendant Paulson misrepresented the nature and scope of the defendant's Washington contacts, right? She said there was none, and there's not none, in her declarations filed to support the motion to dismiss. She filed shit under penalty of perjury that's contradicted here, and it's not true. So defendant says shit that's not true. No. Defendant says shit in her sworn declarations under penalty of perjury that is at odds with what Lori-Ann says. So if Lori-Ann's telling the truth, then what KJ said is not the truth. So conflict. Notably, Barnhart's testimony centers on the same issues that Brown admits were the subject of his former representation, and her testimony is not favorable to Brown and his current clients. 75. Defendant's motion to qualify, docket 63 at 11. The only interest even hinted at in the second Barnhart declaration is Barnhart's alleged possession of, quote, information that contradicted testimony of Paulson provided in support of the motion to dismiss. Interesting. In fact, Brown alleges that Barnhart's testimony in the signed Barnhart declaration changed the, quote, first story she told him by 180 degrees. 76. Defendant's motion to qualify, quote, the 150 emails exchanged between the undersigned and Ms. Barnhart over the previous 18 days were perfectly consistent with the unsigned declaration. The shit that she said in the emails is the shit that's in the declaration, which she was eager to sign under oath until she was washing her hair, and contradicted the testimony they were putting in front of her to sign in the signed Barnhart declaration. Okay. That Mr. Brown contends that Barnhart's testimony is now opposite is enough to establish adversity. So breaking that down, because Brown is saying what Lori-Ann said to us and what Lori-Ann said to you is different, then the things are at odds. That Brown contends Barnhart's testimony is now in the opposite position is enough to establish adversity. The crux of the adversity inquiry centers on a lawyer's duty of loyalty. 77. Parties are allowed to switch sides. Lawyers are not. Accurate. The underlying question is whether the lawyer was so involved in this matter that the subsequent representation can be justly regarded as a changing of sides in the matter in question. 79. RPC. Loyalty and independent judgment are essential elements in the lawyer's relationship to the client. Concurrent conflicts of interest can arise from the lawyer's responsibilities to another client, a former client, or a third person, or from the lawyer's own interests. Unforeseeable developments such as realignment of parties in litigation might create conflicts in the midst of a representation. So I represented Lori. She was on our side and she switched sides, and now she's at odds with me, Brown. But me, Brown, can't switch sides. So now Lori is at odds with my client, KJ. Therefore, I cannot be involved. Okay. Not only, hold on. The underlying question is whether the lawyer was so involved in the matter that representation can be justly regarded as changing sides. Not only is Barnhart's testimony unfavorable to defendants, for sure, and Mr. Brown, but also in nearly every one of defendants' filings since January 13th, of which there are many. Defendants and Brown have attempted to use Barnhart's communication with Brown to discredit her. Preach! Accuse her of submitting false statements under penalty of perjury and or allege that she did not have capacity to execute the signed Barnhart Declaration. Right at odds. Oh, I see. It says conclusion. And then we're going to questions. Moreover, if and when this case proceeds, oh God, when? Mr. Brown may need to cross-examine in a deposition or a trial Miss Barnhart about these exact same issues, including issues raised in confidence during the attorney-client relationship. And we know things were raised in confidence because they're filed under seal for the sole purpose of trying to create doubt as to whether Barnhart gave truthful testimony in the signed Barnhart Declaration and or is a competent witness. Further, if Barnhart testifies at trial on any facts not favorable to defendants to represent Ms. Paulson to the best of his ability, Brown must attempt to discredit this testimony. Literally their job. That is, again, it is... it is in defendant's best interest. He's like, play it again. Like, play it again. Play it again. It is in defendant's best interest for Brown to try to create doubt as to whether Barnhart is competent to testify. Right? That's what he's done over like 3 motions now. And or, which you can't do if you're a former client, and or convince a jury that she committed perjury when she testified against defendant Paulson. Right. But if he represented her, he can't do that. Accusing a former client of either incompetence or a crime to benefit another client is in the same matter could not be a clearer conflict of interest. I agree. Therefore, Brown and his firm cannot exercise their duty of loyalty to both Paulson and Barnhart in the same matter. Conclusion, boom goes the dynamite. That's not what it says. And that's it. That is the end. Oh, that is the end. We have reached the end of the road. No, not the end of the road. The end of the road's such a sweet song. We're more like, it's the end of the world as we know it, and I feel fine. That's where we're at right now. Do we feel fine? How do we feel? How do we feel? Hour and 30 minutes. Chat, have you hit the like? Have you subscribed? Have you done the YouTube things? Do you have questions? Let's answer some questions. I've missed super chats. Thank you for the super chats. I'm going to try to pull them up in the back end and get to some of them and get to some questions. But do we feel like we're at the end of the road? Do we feel like we're at the end of the road? The end of the... No, it's the end of the world. As we know it, and I feel fine. What's the next step? I don't even know, Frank. I don't know what's happening. I'm teasing. I hope that the next step is the judge rules on this shit or rules on jurisdiction. What should happen is that we rule on jurisdiction and we all move on. After jurisdiction's determined, then there should be an answer from the defendant, from KJ, saying, I deny all this shit anyway, or filing cross complaints, or both. We should all move on. We should all get to move on. That's what should happen next. We should all get to move on. It's time to get to questions. My voice has gotten Crazy. It's time to get to questions. And the mods left me a note that Lady Chiffa is here from Siberia. Thank you very much for being all over the place, you guys. I'm pulling up the back ends. We love a clear motion, don't we? We get a clear motion. Well, Dula, there are declarations that say things and then those things change, and some of those things seem to not be true. Like, I don't have any subscribers in Washington. Seems to not be accurate. I don't know, Lorianne. We're not friends. Well, Saltz said in his last motion in declaration that he's seen the DMs and there are hundreds of interactions. So testifying, I don't know her. I've got questions. Octonation, thank you for the super sticker. And Land Walrus, thank you for becoming a channel member. You guys can do that. If you hit join or go to Law Nerds Unite, you can be channel members. We do things. Text Crew has a VIP list. There are members only live streams and such. Has the court set a date to rule on jurisdiction? Nope. Wouldn't it be nice? Nope. KJ deleted her Twitter. Does that mean all of the DMs are gone? I don't know when KJ deleted her Twitter. It should be recovered. We don't know if it's preserved somewhere. But that if things are deleted, there's a motion to not delete your shit. There's a court order to not delete your shit. So that would be a problem. Question. We call shots for you. So partake. Yeah, I'm partaking in water because I still have a few things I have to do tonight, and my voice is already getting, and alcohol can make that worse for me. Wouldn't Brown be pulled off benefit him? I mean, not with the amount of money that's gone into that, because if my attorney got yoinked or yeeted because of their actions, I would be like, the shit that I've paid you, we need to have a conversation. I'd be pissed. He's not doing a good job at this case. Does he miss payment if he doesn't see it through? It depends on the fee structure. Oops, I hit it again. I mean, this is just a fucking mess, you guys. This is all a mess. And look, we're not going to cover other things that look like this, I don't think, because this is such a mess. It's such a mess. Like, it's just a mess. I feel like we've earned a battle rap between Brown and Salty. I think Salty would Swiffer wedge at the floor with him. I mean, I have no idea the type of rappers either counsel would make, but we definitely see their words in writing. What are the pros con of Brown's withdrawing his motion for sanctions? It looks like Saltz just wrote him into a corner. Faith, you're right. Saltz did write him into a corner, but he also loses faith if he loses faith. Your faith loses faith if he withdraws them in front of the court. Also, if those are client directed, then the client would have to agree to withdrawing them, and that's a problem too. There we go. Oh, thank you. You guys add some likes. That would be great. It'd be fantastic. Agreed. And it said in Saltz's last motion, like, the one driving up the money and the one driving up the litigation is Brown. He's the one driving everything up. Saltz trying to show the court in the last two filings the reason Brown should be sanctioned instead of him without bringing a motion. I think Saltz is clearing his own name. I think Saltz is laying the groundwork, and I think Brown came in punching. Asking for sanctions is a big thing, and it should only be reserved when absolutely necessary. And I don't think it was necessary in this case at this time. And so Saltz had no real option but to bring it back. But if Brown hadn't done what he had done, Saltz couldn't have flipped it on him. Like, you can't Uno reverse someone who's not playing the game. So if Brown hadn't said things to the court that were quotes that weren't quotes and things like that, it wouldn't have all come up. Like, Saltz is pointing out the mess. Brown made the mess, though. Is it normal for a court to wait this long to rule on jurisdiction with this much litigation going on? Yes, because it bumps back every single time Brown files something new. It's just pushing it back. Question, is this a different response from Saltz than last week? Yes, this is a different response because it's on a different motion. It's on the motion to qualify counsel. So yes, it's different. I missed a few super chats. Let me get to those. I still haven't gotten to pull up the back ends yet. I will as fast as I can. I would love to hear the judge say, knock it off, scrub lord. She has been so patient. The court has been maybe too patient. She told them all to knock it off in the status conference. I'm waiting to see what happens with all of this. I imagine that this will be ruled on very soon, saying what we're not doing is this. If Babs kicks this out of Washington, how soon do you think Tati will file in Wisconsin? Pretty close. Can Brown recuse himself before Babs yells at him? No, because Babs would have to allow him to recuse himself. The court has to approve that. And at this point, it's not going to happen. Question, with the amount of money KJ is whacking up with Brown, do you think they were sure they could get Tati to pay attorney's fees? I mean, you can never be sure what's going to happen in litigation. You can never assure an outcome. You can never know. Shit happens. I don't know. I don't know the play here. I told you all very much. I don't understand the play here. This came at the perfect time. On my way to the hospital to find out if I'm 6 to 8 months pregnant or have cancer or something just as serious. Katie, keep us posted. Keep us posted. Question, how do you tell your client you messed up like that? By letting people read it on YouTube. You have very real conversations with them. We don't know what's going on behind the scenes with them. We don't know if this is, I can't imagine what strategy this would be, but we don't know if this is being client pushed, like file it, go, get it. I need to do a TikTok with that song. It's like motion, file it, hit it. We don't know if this is client driven with do it. But even if it is, Brown should also be doing it within the bounds of what's proper. If your client is like, can't we make this go faster? What you don't do is file a motion to shorten time that you legally can't do. Can Lori Ann take any type of action against Brown for all he has disclosed in his declarations? Yes. It seems like they were in the items under seal. Yes. Only she knows the full extent of that, but yes, she could. She would have standing to do that. I wonder what the judge is thinking about this. Me too. And I imagine it starts with, what the fuck is this shit? I imagine that's where it begins. Maybe not in those exact words because federal judge, but possibly. Wouldn't it be great if KJ deleted Twitter before the filing to not delete? Oh, that's a whole, we've covered that. Eileen, I talked about that with the motion for the motion to not delete your shit. I cover that timeline pretty thoroughly with the motion to not delete your shit. Once you're on notice from October 31st, after October 31st, it would become a problem. Couldn't Saltz just say, hey, instead of going back and forth, your first motion to dismiss makes no sense and you can't change it, so let's proceed without the BS? That's what should have happened. But here we are. I'm going to take a few more. It is 7:20, so I'm going to have to go eat dinner in just a second. DJ's wife, if Tati didn't care to have Saltz clear his name, could she tell him no? And if so, could Saltz do it on his own? That's a great question. No. All of the motions Brown has filed require a response from the other side, like legally require, like you must respond. Thou shall respond. So no, he had to respond. That wasn't optional. That wasn't a variation. Question. It seems like KJ listened to the judge and has stopped talking about the case on social media. Is that true? Has hell frozen? I don't know. I'm blocked. I don't follow that closely, but I hope so, because if she talks about it, Saltz will talk about it, everybody will talk about it, and it'll be a big mess again. Question, is this a monument to the gods of professional conduct? I mean, this is a whole fucking bar exam at this point, because there is so much professional conduct stuff in here. These are great. Look, anyone that's in law school, these are great hypotheticals. These are wild fact patterns, different than what you normally see. It's very, very interesting. Can Tati or the other person just say F this nonsense and refile and get it over with and get to the actual issue at hand? No, because they're still in this jurisdiction. So not really. Not really. How do motions to disqualify work? They don't. So we talk about it in this motion. This is not how this works. So they don't. It's not how that works. Question, who needs to pay for Saltz's response to these motions? Tati. And if Tati wins, then KJ. If Tati gets lawyer's fees when she wins. And if she loses, then Tati. And she has to pay, could pay some of KJ's lawyer's fees on some of the counts. Why was the ability to request a speedy trial that got banned? It wasn't a request for speedy trial. It was a request to shorten time. And it's because the state of Washington changed the law. And we have a video about that on the channel. But that's why. I answered that. How does a case become case law? If the motion were to get granted, would it become a precedent? Ooh, that's a much longer question about what becomes precedent and what doesn't. But generally, when things go up through the appellate courts and the appellate court clarifies the law and then it goes to the Supreme Court, they become precedent. Like the courts are doing these things. So we're at the very beginning stages. Could this court go up? Could this case go up on appeal? Fucking probably at some point, just because why not? Because we're here, 7 years later going, well, we're in the Supreme Court now, or the state Supreme Court. What is it? What it do today? But cases have to go up and then the higher courts, the appellate courts clarify the law and then it becomes precedent. That's a very rough and dirty explanation. Can Tati just file where KJ lives instead of waiting for the motion to dismiss in Washington? Tactically, I don't think that they would. Could they? I mean, I don't know why they would do that. There's no benefit for them because they very well could win this motion. Could they legally? I mean, they could they could withdraw the suit here and file it, but I don't know why they would, because they could still win that motion and be where they're at. And the judge is already going to be annoyed with Brown for all of this, so why lose that? Could KJP fire Brown at this point? It would be hard because the judge would have to let the lawyer out of it, and the lawyer's already dug this hole. So it would be tough. Question, can they appeal the ruling on jurisdiction? If there's an appealable issue, yes. Question, what are the next filings due? Nothing. Nothing else is due. Rulings. We need rulings. There's nothing left to do. There's nothing left to do. Motions to disqualify don't work. We talked about this earlier in the stream. There is really not... Oh, the motion to disqualify. Sorry, I was reading that as motion to qualify. A motion to disqualify was also laid out earlier in this reading, where a lawyer could say that lawyer for this reason cannot represent this client. So if Saltz had filed this response as a motion to say this is why Brown can't still be on this case, then the court would evaluate it and see if Brown could still be on the case. That's not what got filed here. Brown made up his own thing and filed a motion to qualify. But everything Saltz laid out in this would be why or how a motion to disqualify would be filed. And Saltz the attorney who thinks the other attorney has an issue would file and say that attorney can't still be here. Hopefully that answers it. The mods are the best. Can you all give the mods a huge thank you? I am going to go and say thank you for some of the earlier super chats that I missed because I was reading through this, and then it is twinkle twinkle time and we are going to go. I am hungry. It is going to be time to go. Oh, sorry. Dipebot was not who I was looking for. I was looking for Red Bag. Twinkle, 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 twinkle. Yes, I know. Almost 3K. Thank you, guys. Go ahead and hit those likes. Let me pull these up real quick. Thank you guys for the love for the mods. Much appreciated. It is not an easy thing to do, and it is very appreciated. Also, thank you, chat, for being amazing. You guys are great. And we're all on the same page here to talk about the law and shit and be like, what the fuck is even happening? We're all here to understand this better, right? And that is what is so important, is just trying to understand this better. Jackalope, thank you for the super chat. Jen Gerard, hello, lady. Thank you. Bonus time with Emily. Yes, please. Thank you for the super chat. Much appreciated. Jen Barub, I think I pronounced that right. I appreciate your channel, and Law has always given me all the feels, and your channel is my jam. Thank you for giving us such amazing content. You're so welcome. Dog Mom says, so excited to be here. Thanks for breaking it down. You're welcome. Rena says, I've been here since your Rachel Hollis videos, maybe 3,500 subs. Thank you. Who could have predicted this? No one. Agreed. Thank you so much for your coverage. You're welcome so much. Melodious, thank you for the super sticker and super chat. Teresa Minnesota, thank you for the super chat. Lawrence said more filings. Right. Creepshow, thank you for the super chat. Just woke up. No idea what's going on. Fair. Thank you. Sandra, thank you. Marcia, thank you. Donald Duck sent me a message on Twitter. I will look at that tonight. I haven't been in my DMs a lot. Jessica, I credit Emily with being the pipeline to LawTube, and it's a good thing. You're welcome. Welcome to LawTube. It's fun here. Kathy says, is this even about Tati and KJ anymore? Not right now. Is this about the attorneys trying to prove who has the biggest eggplant? I mean, I've made that mention a few times. But once you come out with the motion for sanctions, it has to be dealt with. Like, it has to be dealt with. It has to be dealt with. Meline said, have to go back to work. Watch the rest later. You're welcome. Thank you. Charlie, thank you. Just wanted to say I love you before I go diving back into the beginning as a part of the replay crew. Thank you so much. Thank you, Stuart, for the super sticker. Donald Duck. Brown lost his participation award. Thank you for that. Donald Duck playing My Heart Will Go On the penny whistle. Sounds like a 5-year-old. Madeline, hi, T is so adorable. Thank you so much. I'll let him know. Happy birthday to him. Kaylee, my birthday was on the 9th. So from a fellow Pisces, happy birthday. T, Pisces are creatives. So the video shorts make sense. I know he plays the guitar, he draws. He's very much a creative kid. And I will, if you guys want me to, let me know in the chat. Do you want me to put a link to his short that he made in my channel tab? Like, I normally don't spam you guys with that kind of stuff. I did send it to a few people, but I normally don't spam you guys with that kind of stuff and be like, look at what my kid made. But if you want to see his short, do you want me to put it in my community tab? I'll put it in. Let me know in the chat and I'll do it. Lori Smith said, we appreciate you. I'm good to see you, Lori. Peapot Fairy said, at this point, can we be justified in declaring Brown incompetent? No, we can't. We're not besmirching. We're confused by Brown's behavior. I mean, way early in this, people were like, Brown sus, Brown sus. And so maybe that's just his nickname is Brown sus because it's sus at this point. Okay, you guys are all here for it. All right, I'll add it in my community tab. I will absolutely add it. So I will add it. I will add the short. It's literally like 16 seconds long. So I will. Octonation, thank you for the super sticker. Lynn E, I feel like we've earned a battle rap. Okay, so I am caught up. Thank you, everybody. It is time for me to go eat dinner. You guys, we have Friday Night Live tomorrow night. I was going to talk about Girardi updates, and I'm still going to talk about Girardi updates, and then I will answer more questions about this. I have some thoughts. I haven't gotten to digest all of this motion, so it needs to, we need to soak in it a little bit. And I will do thoughts on this, and I will do thoughts on this, court of public opinion, and updates in the Girardi case tomorrow night. So tomorrow night's Friday Night Live. Maybe the judge will rule on something between now and then. Can we just, monuments to the gods of federal court, please rule on something. Maybe just read this and be like, yeah, fuck that motion. Anything. Give us one ruling. There are 3 things outstanding. Any ruling. I would love that. I would love that so much. Just one little ruling, Your Honor, please. For Friday night. So if anything happens tomorrow, we will talk about it tomorrow on Friday Night Live. So that is my goal, is to talk about it then. So what else? That's really it, you guys. I don't have much more. You guys are asking for Lawyer Cat. I don't have Lawyer Cat up and ready. I'm sorry. I don't. It's not ready. That's my bad. It was very busy today. I apologize. I'm sorry. We will get to Lawyer Cat tomorrow. I promise. We will do it tomorrow. Lawyer, let me see if I can pull it up. I see y'all. I see you. Let's see if I can find it. Why is it not showing up? It is not showing up. Probably because I didn't save it on this thingy of the thingies. Let me see. Nope. Nope. Totally can't find it. Totally can't find it. Sorry, y'all. We're going to have to do it another day. I will get it queued up for tomorrow. I can't do Lawyer Cat if it's not ready. Because then I would be like, not, well, you know what? I found it. I found it. This is what it is. This is just what it is. Look, we're pandering at this point. We're pandering. And so if we're going to pander, you guys, if you haven't joined the text crew, I finally got the link working right. So from your mobile device, just go to textemily.com and you can join the text crew. The VIP members have a VIP text crew. But y'all, if you haven't joined yet, join. We're going to pander as Lawyer Cat. Meow. 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 I'm a real attorney. I'm here live. I'm asking you to go ahead and like this video, give this video a big old thumbs up. And if you want to, if you enjoy this content, tag me on social media. If you're going to share Lawyer Cat. If you're going to share Lawyer Cat, tag me on social media at the Emily D. Baker. If you don't follow me on social media, come on over. I do different things on the Instagrams and on the Twitters and on Clubhouse. I'm all over the place. ADHD. Totally true. Follow me on social media at the Emily D. Baker. I am a real lawyer. I'm not your lawyer. I'm so glad I'm not the lawyer on this YouTube case, but I cannot wait to talk about this with you guys tomorrow. Just textemily.com, join the channel, do the YouTubey things. I appreciate you guys so much. I cannot wait to be back with you tomorrow. And I think I need to say goodbye as myself. Wait, where are we going? No, I am lost. And now I am found. Thank you so much for being here. I appreciate you. This is the wrong camera 100%. What is even happening? That's not the right camera. That's the right camera. Look, this one's way better. So tired. I absolutely won't. Little Red Star, he told me and he texted me. Thank you guys. This was like 17 wrap-ups. Thank you, Truth Sleuth. Good to see you. Good to see everyone. I appreciate you so much. I will talk to you next. I am ready for dinner, and I will talk to you in the next one. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just textemily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.